If you are newly married, it's really important that you and your new spouse both update your wills. So let's say that you're married and your spouse was married before, and your spouse had an estate plan, had a will, and that will gives everything to his former spouse. Well, the question is, if your spouse dies, what do you get? How will that will be interpreted? The answer depends a lot on the state that you live in. In Washington, we have an RCW, a statute that says that if the will, let's say your husband's will, says everything goes to my spouse, but that's his old spouse he's divorced from, Washington figures that he really didn't mean that ex-spouse shouldn't inherit anything from him. So there are protections in our statutes in Washington to make sure that old spouse doesn't get what she shouldn't get. That might give you some comfort, but please don't rely on that. Seek out the services of an estate planning and elder law attorney. Get new wills and make sure your new wills say exactly what should happen when you and your new spouse, when you die. One of the things I also want to mention is, let's say that ex-spouse was not just who was going to inherit under your new husband's will, but under his 401k. And he never changed it. He divorced her, but he never changed it. Well, there is the possibility that ex-spouse will still inherit the 401k, depending on what the default provisions of that plan say. There is case law in Washington that says that ex-spouse, she gets it. Why is that? Because ERISA, which is a federal statute, takes precedence over any Washington statute that says otherwise. So especially in this type of situation, and if there's a 401k or other employee benefit plan, makes it even more important that you and your new spouse get an estate plan that suits you and your new situation.